closest pediatrician. Those 30 days are up, and my kid now has a broken leg. That means I have to drive probably an hour or two to go find another doctor because you're refusing to take care of my kid. I mean, that's my question.
It could happen.
It could, I mean, that's why the state provides for a 30-day window, so that that person has the option to either come up with an alternative plan or to talk with the pediatrician and say, gosh, I need 60 days, I need 90 days, it's too hard to find somebody. There needs to be communication during those 30 days, you're right.
And I'm representing many healthcare provider who has terminated relationships with patients, and we give them the language to use from the statute in their letters. And then we also will refer them to ambulatory care or emergency care in the event something urgent or emergent occurs, even within those 30 days. But it's the patient's responsibility to identify a new healthcare provider to whom the medical record and medical information will be transferred. So, but there is that rub, and there is the potential for there to be animosity in that relationship. 4 minutes in counting with 3 minutes. So any other questions?
This is for the client section.
Yeah. I would.
I just have a quick question.
Yeah.
Last minute. Under the intent of beneficence, can you talk a little bit about who the audience is? So you said, do no harm. To whom? Do the most good. For whom? So that seems to me to be the crux of the physician's position in determining how they continue or not continue the treatment for people who are opting out of vaccination. So if you could just speak to that in the 2 minutes you have left, I'd appreciate it.
Sure. Won't even take 2 minutes. Really, the audience for those two phrases is generally the individual patient with whom there is an applied contract for services to be rendered by that healthcare provider to the patient. And so that answers it really quickly. But then there's the other kind of higher level analysis around do that which is good. Then who's the audience there? It's clearly the individual. But you can also argue, and it has been argued many times, that society in general, community, is also an audience to those 2 points.
Yeah.
Yes?
Well, how about the rest of the doctor's patients that might be exposed to what this one unimmunized child could bring to his office? So if you look at the rest of his patients versus the one child as the audience, that do know the most good is to the other patients by terminating the relationship. Right?
Yeah, that's been argued too. Yeah, certainly. And it's real. I mean, when you walk into a doctor's office and you see signs that say, please wear a mask if you have the flu, please wear a mask if you're not immunized. We have, patients with measles or, varicella, chickenpox. I would just say from a legal perspective, and wrapping up here, that the challenges to state laws around vaccination are, I think, an effective challenge is going to be born out of the evolution of case law around privacy rights. And so we'll see what happens there. And if you look at case law where there's been cracks made in the armor of pro-immunization, it is really around privacy rights. But I would say that given the extensive jurisprudence around this issue, that as long as there's a public health need for widespread vaccination, and that need really truly exists within communities, the courts will not recognize a privacy right to refuse state-mandated vaccinations, and will always uphold police powers for state-mandated vaccinations. That's my opinion.
All right, we've run out of time. Thank you both.